Please be seated. The sitting is open. For proceeding, I wish to tell that the court has learned of passing away of His Holiness Somdet Phra Nyanasamvara, Supreme Patriarch of Thailand. On behalf of the court, I wish to extend deep sympathy and condolences to the people of Thailand. La Cour se réunit aujourd'hui en application de l'article 58 du statut pour rendre son arrêt dans l'affaire relative à la demande en interprétation de l'arrêt du 15 juin 1962 en l'affaire du temple de Preah Vihear, Cambodge contre Thaïlande. Cette instance a été introduite par le dépôt au greffe de la Cour le 28 avril 2011 d'une requête du Cambodge contre la Thaïlande dans laquelle, se référant à l'article 60 du statut de la Cour et à l'article 98 de son règlement, le Cambodge a demandé à la Cour d'interpréter l'arrêt qu'elle a rendu le 15 juin 1962 à l'affaire du temple de Preah Vihear. Le même jour, après avoir déposé sa requête, le Cambodge, se référant à l'article 41 du statut et l'article 73 du règlement, a également déposé au greffe une demande en indication des mesures conservatoires afin de, et je cite, faire cesser les incursions de la Thaïlande sur son territoire. Fin de citation. Le 18 juillet 2011, la Cour a rendu une ordonnance indiquant des mesures conservatoires à l'intention de deux parties. Comme il est d'usage, je ne donnerai pas la lecture du paragraphe introductif de l'arrêt qui retrace l'historique de la procédure et reproduise les conclusions des parties. Par ailleurs, j'omettrai ou résumerai certains paragraphes de l'arrêt. Le texte intégral de celui-ci sera bien évidemment disponible dès la fin de la séance. Je commencerai donc la lecture au paragraphe 14 de l'arrêt. Le temple de Preah Vihear s'élève sur un éperon du même nom, situé dans la partie orientale de la chaîne de Dangrek, qui, d'une façon générale, constitue dans cette région la frontière entre les deux pays, le Cambodge au sud et la Thaïlande au nord. Le 13 février 1904, la France, dont le Cambodge était alors un protectorat, le Siam, ainsi que la Thaïlande était alors dénommée, signèrent une convention, au terme de laquelle la frontière, dans le secteur de Dangrek, devait suivre la ligne de partage des eaux. La convention de 1904 prévoyait la création des commissions mixtes composées d'officiers désignés par les deux parties et chargés de procéder à la délimitation de la frontière entre les deux territoires. La première commission mixte fut ainsi établie en 1904. L'étape finale de l'opération de délimitation devait être l'établissement et la publication de cartes, tâche qui fut confiée à une équipe de 4 officiers français, dont 3 avaient été membres de la commission mixte. Cette équipe établit en 1907 une série de 11 cartes couvrant une grande partie de frontières entre le Siam et l'Indochine française dont le Cambodge faisait partie. Elle dressa notamment une carte intitulée Dangrek, commission de délimitation entre l'Indochine et le Siam, sur laquelle la frontière passait au nord de Preah Vihear, laissant ainsi le temple au Cambodge. Cette carte fut dûment communiquée au gouvernement siamois en 1908, mais ne fut jamais approuvée par la commission mixte celle-ci ayant cessé de fonctionner plusieurs mois avant que la carte soit dressée. Après l'accession du Cambodge à l'indépendance, le 9 novembre 1953, la Thaïlande occupa le temple de Preah Vihear en 1954. Les négociations entre les parties concernant le temple n'aboutirent pas et le 6 octobre 1959, le Cambodge saisit la Cour par requête unilatérale. La Thaïlande présenta des exceptions préliminaires à la compétence de la Cour. Dans son arrêt du 26 mai 1961 sur les exceptions préliminaires soulevées par la Thaïlande, la Cour se déclara compétente pour connaître du différend. Lors de la phase de l'examen au fond, le Cambodge s'appuya sur la carte intitulée d'un grec Commission de délimitation entre l'Indochine et le Siam, mentionnée ci-dessus, qui était annexée à ces écritures et fit dénommer carte de l'annexe 1. Il fit valoir que celle-ci avait été acceptée par la Thaïlande et avait été intégrée au règlement conventionnel, devenant de ce fait obligatoire pour les deux États. Selon le Cambodge, la ligne représentée sur la carte de l'annexe 1 était ainsi devenue la frontière entre les deux États. La Thaïlande contesta qu'elle eût accepté la carte de l'annexe 1 ou que celle-ci fût d'une autre façon devenue obligatoire à son égard, soutenant que la frontière entre les deux États suivait la ligne de partage des eaux, comme le prévoyait la Convention de 1904. Il en résultait, selon elle, que le temple était situé en territoire thaïlandais. La Cour rappelle que le dispositif de l'arrêt de 1962 se lit comme suit, et je cite. La Cour dit que le temple de Preah Vihear est situé en territoire relevant de la souveraineté du Cambodge. Dit en conséquence que la Thaïlande est tenue de retirer tous les éléments de forces armées ou de police ou autres gardes ou gardiens qu'elle a installés dans le temple ou dans ses environs situés en territoire cambodgien et que la Thaïlande est tenue de restituer au Cambodge tous objets de catégorie spécifiée dans la 5e conclusion du Cambodge qui, depuis la date de l'occupation du temple par la Thaïlande en 1954, aurait pu être enlevés du temple ou de la zone du temple par les autorités thaïlandaises. Fin de citation. À la suite du prononcé de l'arrêt de 1962, la Thaïlande se retira des bâtiments du temple et érigea une clôture de barbelés séparant les ruines du temple du reste de l'éperon de Preah Vihear. Cette clôture suivait le tracé d'une ligne représentée sur la carte jointe à une résolution adoptée par le Conseil des ministres thaïlandais le 10 juillet 1962, mais qui n'a été rendue publique que dans le cadre de la présente instance. Par cette résolution, le Conseil des ministres thaïlandais établissait ce qu'il considérait être la limite de la zone dont la Thaïlande était tenue de se retirer. En ce qui concerne la compétence de la Cour, le Cambodge fonde sa demande en interprétation sur l'article 60 du statut de la Cour. La Cour rappelle tout d'abord que, je cite, la compétence que l'article 60 du statut lui confère est subordonnée à l'existence d'aucune autre base ayant fondé dans l'affaire initiale sa compétence à l'égard des parties, fin de citation, et que, je cite, en vertu de l'article 60 du statut, elle peut connaître d'une demande d'interprétation dès lors qu'existe une contestation sur le sens et la portée de tout arrêt rendu par elle. Fin de citation. Selon la jurisprudence de la Cour, une contestation au sens de l'article 60 du statut doit porter sur le dispositif de l'arrêt en cause et ne peut concerner les motifs que dans la mesure où ceux-ci sont inséparables du dispositif, cela étant une divergence de vue sur la question de savoir si tel ou tel point a été décidé avec force obligatoire, constitue, elle aussi, un cas qui rentre dans le cadre de l'article 60 du statut. La Cour observe que les éléments et déclarations remontant à la période qui a immédiatement suivi le prononcé de l'arrêt de 1962 démontrent clairement que la Thaïlande considérait que la Cour n'avait pas défini l'expression « environ du temple » employée au deuxième point du dispositif et que, partant, il lui était loisible de déterminer unilatéralement les limites de ces environs. La position de la Thaïlande trouve en particulier son expression dans la résolution du Conseil des ministres thaïlandais de 1962 qui a défini, je cite, « l'endroit où se situait la limite des environs du temple dont la Thaïlande était tenue de retirer ses forces de police, gardes et gardiens ». En application de cette disposition, la Thaïlande a érigé une clôture de barbelés sur le terrain le long de la ligne établie par la résolution et installé des panneaux portant la mention, je cite, « Les environs du temple de Preah Vihear ne vont pas au-delà de cette limite ». Fin de citation. Contrairement à ce qu'indique la Thaïlande, il ressort des éléments versés au dossier que le Cambodge ne considérait pas que le retrait opéré par la Thaïlande assurait l'application pleine et entière de l'arrêt de 1962. Le Cambodge émit en effet des protestations contre la présence thaïlandaise sur un territoire que, selon lui, la Cour avait, dans son arrêt de 1962, reconnu comme étant cambodgien. Il se plaignit également de ce que la clôture de barbelés érigée par la Thaïlande empiétait assez largement sur ce territoire, contrevenant de la sorte à l'arrêt de la Cour. Cette divergence de vue est réapparue dans la correspondance des parties qui a fait suite à la demande d'inscription du site du temple sur la liste du patrimoine mondial de l'UNESCO présentée en 2007-2008 par le Cambodge. Selon la Cour, ces événements et déclarations démontrent clairement que, au moment du dépôt de la demande en interprétation du Cambodge, il existait une contestation entre les parties quant au sens et à la portée de l'arrêt de 1962. Il en vient ensuite à l'objet précis de cette contestation afin de déterminer si celle-ci entre dans le champ de sa compétence en vertu de l'article 60 du statut. La Cour relève que les deux parties admettent qu'un désaccord les oppose sur la question de savoir si la Cour a ou non, dans l'arrêt de 1962, décidé avec force obligatoire que la ligne de la carte de l'annexe 1 représentait la frontière entre elles dans la zone du sample. La divergence de vue entre les parties sur cette question ressort également des positions exprimées par celle-ci à l'occasion des événements et dans les déclarations examinées ci-dessus, positions qui ont été précisées dans le cadre de la présente procédure. La Cour considère, en outre, que les positions exprimées par les parties dans la période qui a suivi le prononcé de l'arrêt de 1962, ainsi qu'à la suite de la demande du Cambodge, tendant à l'inscription du site du temple sur la liste du patrimoine mondial, et dans le cadre de la présente procédure, révèlent également leur divergence de vue quant au sens et à la portée de l'expression « environ situé en territoire cambodgien » employée au deuxième point du dispositif de l'arrêt de 1962 et quant au lien entre ces points et la conclusion que la Cour a énoncée au premier point du dispositif, à savoir que le temple est situé en territoire relevant de la souveraineté du Cambodge. La Cour en vient enfin à l'affirmation selon laquelle les parties sont en désaccord quant à la nature de l'obligation de la Thaïlande de se retirer du temple et de ses environs situés en territoire cambodgien, telle qu'elle résulte du deuxième point du dispositif de l'arrêt de 1962. Il ressort de la correspondance des parties dans le contexte de la demande d'inscription du site du temple sur la liste du patrimoine mondial, ainsi que des affrontements armés qui sont produits dans la zone frontalière voisine du temple, que, avant le dépôt de la demande en interprétation du Cambodge, les parties étaient en désaccord sur la question de savoir où, selon l'arrêt de 1962, les personnels thaïlandais avaient le droit de se trouver. Cette divergence de vie a été confirmée par les écritures et plaidoiries en la présente instance. À la lumière des considérations exposées ci-dessus, la Cour conclut que la contestation entre les parties sur le sens et la portée de l'arrêt de 1962 se rapporte à trois aspects spécifiques de cette décision. Premièrement, il existe une contestation sur le point de savoir si, dans l'arrêt de 1962, la Cour a ou non décidé à force obligatoire que la ligne représentée sur la carte de l'annexe 1 constituait la frontière entre les parties dans la zone du temple. Deuxièmement, il existe une contestation étroitement liée à la précédente sur le sens et la portée de l'expression « environ situé en territoire cambodgien » employée au deuxième point du dispositif de l'arrêt de 1962, point dont la Cour a dit qu'il était une conséquence de la conclusion énoncée au premier point, à savoir que le temple est situé en territoire relevant de la souveraineté du Cambodge. Troisièmement, il existe une contestation sur la nature de l'obligation de retrait que le deuxième point du dispositif impose à la Thaïlande. Compte tenu des vues divergentes des parties sur le sens et la portée de l'arrêt de 1962 exposé ci-dessus, la Cour considère qu'il est besoin d'interpréter le deuxième point du dispositif de cet arrêt, ainsi que la portée juridique de ce que la Cour a dit concernant la ligne de la carte de l'annexe 1. Dans le cadre ainsi défini, la demande du Cambodge est recevable. Au vu de ce qui précède, la Cour conclut qu'il existe entre les parties sur le sens et la portée de l'arrêt de 1962 une contestation entrant dans les prévisions de l'article 60 du statut. En conséquence, la Cour est compétente pour connaître de la demande d'interprétation de l'arrêt de 1962 présentée par le Cambodge et celle-ci est recevable. La Cour en vient ensuite à l'interprétation de l'arrêt de 1962. I shall now continue my reading of the judgment in English. The Court recalls that its role under Article 60 of the statute is to clarify the meaning and scope of what the Court decided in the judgment which it is requested to interpret. Accordingly, the Court must keep strictly within the limits of the original judgment and cannot question matters that were settled therein with binding force, nor can it provide answers to questions the Court did not decide in the original judgment. In determining the meaning and scope of the operative clause of the original judgment, the Court, in accordance with its practice, will have regard to the reasoning of that judgment to the extent that it sheds light on the proper interpretation of the operative clause. The pleadings and the record of the oral proceedings in 1962 are also relevant to the interpretation of the judgment, as they show what evidence was or was not before the Court and how the issues before it were formulated by each party. Thailand argues that the principle of non ultra petita precluded the Court from going beyond the submissions of the parties, and that the 1962 judgment must be interpreted accordingly. The principle of non ultra petita is well established in the jurisprudence of the court, and is one reason why the claims contained in the final submissions of the parties in the original case are of relevance in interpreting the 1962 judgment. Nevertheless, that principle cannot justify an interpretation which runs counter to the terms of the 1962 judgment. The court in 1962 necessarily made an assessment of the scope of the petitum before it. Article 60 of the statute does not give the court the power today to substitute a different assessment for that made at the time of the judgment. Cambodia suggests that the head note to the 1962 judgment demonstrated that the judgment determined the course of the frontier in the relevant area. Under Article 95, Paragraph 1 of the Rules of Court, at the time of 1962 judgment, on Article 74, Paragraph 1 of the Rules of Court of 1946 was applicable. The head note is not one of the elements of the judgment, and it does not form part thereof. Moreover, the purpose of the head note is only to give the reader a general indication of the points examined in a judgment. It does not constitute an authoritative summary of what the court has actually decided. The court does not consider that the head note to the 1962 judgment assists in resolving the questions of interpretation raised in the present proceedings. Thailand makes extensive reference to the conduct of the parties between 15 June 1962, when the judgment was delivered, and 2007-2008, when the present dispute may be said to have crystallized. Thailand suggests that this conduct is inter alia relevant to the interpretation of the judgment. A judgment of the court cannot be equated to a treaty, an instrument which derives its binding force and content from the consent of the contracting states, and the interpretation of which may be affected by the subsequent conduct of those states as provided by the principle stated in Article 31, Paragraph 3b of the 1969 Vienna Convention on the Law of Treaties. A judgment of the court derives its binding force from the statute of the court, and the interpretation of a judgment is a matter of ascertaining what the court decided, not what the parties subsequently believed it has decided. The meaning and scope of a judgment of the court cannot, therefore, be affected by conduct of the parties occurring after that judgment has been given. More generally, as the Permanent Court of International Justice made clear, and I quote, "The court, when giving an interpretation, refrains from any examination of facts other than those which it has considered in the judgment under interpretation." End of quotation. Three features of the 1962 judgment stand out when the judgment is read in the light of the considerations set out above. First, the court considered that it was dealing with a dispute regarding territorial sovereignty over the area in which the temple was located, and that it was not engaged in delimiting the frontier. Thus, the court, referring back to its 1961 judgment on preliminary objections, characterized the dispute as one regarding sovereignty over a defined area of territory rather than boundary delimitation. It is also evident in the court's decision that, and I quote, "Cambodia's first and second submissions calling for pronouncements on the legal status of the Annex I map and on the frontier line in the disputed region can be entertained only to the extent that they give expression to grounds and not as claims to be dealt with in the operative provisions of the judgment. End of quotation. No mention was made of either the Annex I map or the location of the frontier in the operative part. No map was attached to the judgment, nor did the court make any comment on the difficulties of transposition of the Annex I map line, a matter which had been discussed by the parties during the 1962 proceedings and which would have been of obvious importance in a judgment on the limitation of the frontier. Secondly, however, the Annex I map played a central role in the reasoning of the court. After reviewing the history of the map and its relationship with the 1904 treaty, the court stated, and I quote, "The real question, therefore, which is the essential one in this case, is whether the parties did adopt the Annex I map and the line indicated on it as representing the outcome of the work of the limitation of the frontier in the region of Preah Vihear, thereby conferring on it a binding character." End of quote. He then considered the conduct of the parties with regard to the map and other practice, including the visit of Prince Damrong to the temple in 1930, when he was received by the French authorities. Although the court considered that the circumstances of Prince Damrong's visit were such as to amount to a, and I quote, "tacit recognition by Siam of the sovereignty of Cambodia under French protectorate over Preah Vihear," end of quote, that incident, together with Thailand's other conduct subsequent to 1908-1909, was treated primarily as confirmation of the earlier acceptance by Thailand of the Annex I map line. The court considered that, and I quote, "Thailand in 1908-1909 did accept the Annex I map as representing the outcome of the work of delimitation and hence recognized the line on the map as being the frontier line, the effect of which is to situate Preah Vihear in Cambodian territory." End of quotation. The court went on to state that, and I quote, "the acceptance of the Annex I map by the parties caused the map to enter the treaty settlement and to become an integral part of it," end of quotation, and concluded that it, quote, "therefore feels bound, as a matter of treaty interpretation, to pronounce in favor of the line as mapped in the disputed area," end of quotation. Thirdly, in defining the dispute before it, the court made clear that it was concerned only with sovereignty in the region of the Temple of Preah Vihear. That this region comprised only a small area is apparent from the 1962 proceedings. Thus, Counsel for Cambodia stated that, and I quote, "the area in dispute in these proceedings is very small indeed," end of quote. This and other similar statements were not contradicted during the 1962 proceedings. The judgment shows that the court considered that the disputed area was a small one. Immediately after the passage in which it defined the dispute as one regarding sovereignty over the region of the temple, the court described that region in the following terms, and I quote, "The temple of Preah Vihear stands on a promontory of the same name, belonging to the eastern sector of the Dangrek range of mountains, which, in a general way, constitutes the boundary between the two countries in this region, Cambodia to the south and Thailand to the north." End of quote. While the Annex I map deals with a part of the frontier region more than 100 kilometers in extent, the court made clear that it had to pronounce upon it only in the disputed area. In the light of these elements in the reasoning of the 1962 judgment, the court turns to the operative part of the judgment. The findings set out in the second and third paragraphs are expressly stated to be consequences following from the decision in the first operative paragraph. It follows that the three operative paragraphs have to be considered as a whole. The task of ascertaining the meaning and scope cannot be reduced to an exercise of construing individual words or phrases in isolation. The Court considers that the meaning of the first operative paragraph is clear. In that paragraph, the Court ruled on Cambodia's principal claim by finding that the temple was situated in territory under the sovereignty of Cambodia. It states, however, that it will be necessary to return to the scope of this paragraph once the Court has examined the second and third operative paragraphs. The principal dispute between the parties concerns the second operative paragraph. In that paragraph, the Court required, as a consequence of the decision in the first operative paragraph, the withdrawal of Thai military or police forces or other guards or keepers stationed by her at a temple or in its vicinity on Cambodian territory. The second operative paragraph did not indicate expressly the Cambodian territory from which Thailand was required to withdraw its personnel, nor did it state to where those personnel had to be withdrawn. The only context in which the paragraph refers to an area of territory, I quote, the temple or its vicinity on Cambodian territory, end of quote, was in indicating which of its personnel Thailand was under an obligation to withdraw, namely those whom it had stationed in that area. Since the second operative paragraph of the 1962 judgment required Thailand to withdraw any of its military or police forces or other guards or keepers stationed by her at the temple or in its vicinity on Cambodian territory, the Court considers that it must begin by examining the evidence that was before the Court in 1962 regarding the locations at which such Thai personnel were stationed. The only such evidence was given by Professor Ackerman, who was called by Thailand as an expert and witness, and who had visited the temple for several days in July 1961 in the course of preparing a report to be submitted in the proceedings. Under cross-examination by counsel for Cambodia, Professor Ackerman testified that during that visit, the only people he had seen at the Preah Vihear promontory were a detachment of Thai frontier police and one temple guard. He stated that the police had been stationed in blockhouses at a camp located to the northeast of the temple, while the guard had lived in a separate house a short distance to the west of the police camp. The location of the police station was subsequently confirmed by counsel for Thailand, according to whom the police camp was located south of the Annex 1 map line, but north of a line which Cambodia maintained was the watershed line. During the 1962 proceedings, Cambodia had advanced an alternative argument that if, contrary to its primary position, the boundary was required to follow the watershed rather than the Annex 1 map line, then it was this Cambodian line which represented the watershed and not the watershed line advocated by Thailand, to which reference has already been made. In the event, the Court found that it was unnecessary to consider the location of the watershed in the area of the temple. Nevertheless, the reference to that line in the speech by counsel for Thailand is significant because, as Thailand has stated in the current proceedings, the Thai Council of Ministers line follows a course very close to that of the watershed line advanced by Cambodia in 1962. It is apparent, therefore, that the Thai police detachment was stationed at the location north of the line subsequently drawn by the 1962 resolution of the Thai Council of Ministers, and thus outside what Thailand considers to be, and I quote, vicinity of the temple on the Cambodian territory, end of quote. When the Court required Thailand to withdraw military or police forces, guards or keepers which it had stationed in the temple or in the vicinity of the temple on Cambodian territory, it must have intended that obligation to apply to the police detachment referred to by Professor Ackerman, since, except for the solitary temple guard, who seems to have been living near the police camp, there was no evidence of the presence of any other Thai personnel anywhere near the temple. Accordingly, the term, I quote, vicinity on Cambodian territory, end of quote, has to be construed as extending at least to the area where the police detachment was stationed at the time of the original proceedings. Since that area lies north of the Thai Council of Ministers line, that line cannot represent the correct interpretation of the territorial scope of the second operative paragraph as Thailand contends. That conclusion is confirmed by a number of other factors. As the court emphasized in its description of the area around the temple is located on an easily identifiable geographical feature. This feature is a promontory. In the east, south, and southwest, the promontory descends by a steep escarpment to the Cambodian plain. In the west and northwest, the ground drops into what Professor Ackerman described in his evidence as a, I quote, valley between the Phnom Trap mountain and the Preah Vihear mountain, end of quote. It is through this valley that access to the temple from the Cambodian plain can most easily be obtained. The hill of Phnom Trap rises from the western side of this valley. A natural understanding of the concept of the vicinity of the temple would extend to the entirety of the Preah Vihear promontory. Furthermore, the court's reasoning regarding the significance of the Annex I map shows that the court considered that Cambodia's territory extended in the north as far as, but no farther than, the Annex I map line. Although Professor Ackerman did not give any estimate of the distances between the various places on the promontory to which he referred in his evidence, it is clear that, for example, the police post which he identified was only a very short distance to the south of the nearest point on the Annex I map line. The court was therefore dealing with a small area with clearly defined geographical limits to the east, south, west, and northwest, and bounded in the north by what the court had stated in its reasoning was the limit of Cambodian territory. In these circumstances, the court considers that the territorial scope of the second operative paragraph must be construed as extending to the whole of the promontory, rather than being confined to that part of it chosen by the Thai Council of Ministers in 1962. Turning to the position of Cambodia, the court is also unable to accept its interpretation of vicinity. In its answer to the question put by a member of the court, Cambodia maintained that the vicinity includes not only the promontory of Preah Vihear, but also the hill of Phnom Trap. There are several reasons why the court considers that this is not the correct interpretation of the second operative paragraph. First, Phnom Trap and the promontory of Preah Vihear are distinct geographical features which are clearly shown as separate on the maps used in the 1962 proceedings, and in particular on the Annex I map, which was the only map to which the court made more than passing reference in the judgment. Secondly, there are certain indications in the record of 1962 proceedings that Cambodia did not treat Phnom Trap as falling within the, quote, region of the temple or temple area, the terms used by the court in defining the scope of the dispute before it. Thus, a former Cambodian provincial governor, Mr. Suon Bon, who was called as witness by Cambodia, testified that Preah Vihear had formed part of his province, but that He saw that Phnom Trap belonged to a neighboring province. Moreover, as explained above, in referring to the area with which the court was concerned, Counsel for Cambodia spoke of its dimensions in terms which would be too small to encompass at the same time Phnom Trap as well as the promontory of Preah Vihear. He also stated that Phnom Trap was not part of the, quote, crucial area, end of quote, with which the court was concerned. Thirdly, there was no evidence before the court of any Thai military or police presence on Phnom Trap in 1962, and no suggestion that Phnom Trap was relevant to Cambodia's claim that Thailand should be required to withdraw its forces. Lastly, Cambodia's interpretation depends upon identifying the location of the points at which the Annex I map line intersects with the watershed line advocated by Thailand. Yet, in the 1962 judgment, the court made clear that it was not concerned with the location of the watershed and did not decide where the watershed lay. It is therefore implausible to suggest that the court had the watershed line in mind when it used the term vicinity. While no one of these considerations is conclusive in itself, taken together, they lead the court to conclude that in 1962, the court did not have this wider area in mind, and accordingly, that it did not intend the term vicinity of the temple on Cambodian territory to be understood as applicable to territory outside the promontory of Preah Vihear. That is not to say that the 1962 judgment treated Phnom Trap as part of Thailand. The court did not address the issue of sovereignty over Phnom Trap or any other area beyond the limits of the promontory of Preah Vihear. From the reasoning in the 1962 judgment, seen in the light of the pleadings in the original proceedings, it appears that the limits of the promontory of Preah Vihear to the south of the Annex I map line consist of natural features. To the east, south, and southwest, the promontory drops in a steep escarpment to the Cambodian plain. The parties were in agreement in 1962 that this escarpment and the land at its foot were under Cambodian sovereignty in any event. To the west and northwest, the land drops in a slope, less steep than the escarpment, but nonetheless pronounced, into the valley which separates Preah Vihear from the neighboring hill of Phnom Trap, a valley which itself drops away in the south to the Cambodian plain. For the reasons already given, the court considers that Phnom Trap lay outside the disputed area, and the 1962 judgment did not address the question whether it was located in Thai or Cambodian territory. Accordingly, the court considers that the promontory of Preah Vihear ends at the foot of the hill of Phnom Trap, that is to say, where the ground begins to rise from the valley. In the north, the limit of the promontory is the Annex I map line, from a point to the northeast of the temple, where that line abuts the escarpment to a point in the northwest, where the ground begins to rise from the valley at the foot of the hill of Phnom Trap. The court considers that the second operative paragraph of the 1962 judgment required Thailand to withdraw from the whole territory of the promontory, thus defined, to Thai territory any Thai personnel stationed on that promontory. The court notes Thailand's argument about the difficulty of transposing the Annex I map and thus of ascertaining the precise location on the ground of the Annex I map line in the area described in the preceding paragraph. The 1962 judgment did not, however, address that question, and the court cannot now, in the exercise with jurisdiction under Article 60, to interpret the 1962 judgment, to deal now with a matter which was not addressed by the judgment. Nevertheless, the parties to a case before the court have an obligation to implement the judgment of the court in good faith. It is of the essence of that obligation that it does not permit either party to impose a unilateral solution. The court recalls that the 3 paragraphs of the operative part of the 1962 judgment have to be considered as a whole. Having determined the meaning and scope of the 2nd paragraph, the court now turns to the relationship between that paragraph and the other 2 paragraphs of the operative part. While there is no dispute within the parties regarding the 3rd operative paragraph, it is nonetheless relevant to the extent that it sheds light on the meaning and scope of the rest of the operative part. The scope of the operative part of a judgment of the court is necessarily bound up with the scope of the dispute before the court. The 1962 judgment defined the dispute which was then before the court as one concerning, and I quote, sovereignty over the region of the temple of Preah Vihear, end of quote. It was entirely consistent with this view of the dispute that the court, having decided in the 1st operative paragraph of the judgment that the temple was located in territory under the sovereignty of Cambodia, determined as a consequence of that finding that Thailand was under an obligation to withdraw its forces and other personnel stationed at the temple or in its vicinity on Cambodian territory, and to restore objects removed from the temple or the temple area. The 2nd and 3rd operative paragraphs each, therefore, imposed obligations with respect to an area of territory which extended beyond the temple itself. The 2nd operative paragraph expressly described this area as Cambodian territory. The 3rd operative paragraph did not do so, but the court considers that such a description was implicit. An obligation to restore artifacts taken from the area of the temple would be a logical consequence of a finding of sovereignty only to the extent that the area in question was covered by that finding. The area with which the court was concerned in the original proceedings, as has already been explained, is small and bounded, except to the north, by readily identifiable geographical features. In these circumstances, the court considers that the terms, quote, vicinity of the temple on Cambodian territory, end of quote, in the 2nd paragraph, and, quote, area of the temple, end of quote, in the 3rd paragraph, refer to the same small parcel of territory. The obligations which the court imposed in respect of that parcel of territory were stated to be a consequence of the finding in the 1st paragraph. In view of the characteristics of the dispute which confronted the court in 1962, in particular the nature of the submissions of each party, the obligations imposed by the 2nd and 3rd paragraphs would be a logical consequence of the finding of sovereignty in the 1st operative paragraph only if the territory referred to in the 1st paragraph corresponded to the territory referred to in the 2nd and 3rd paragraphs. Accordingly, the court concludes that the territorial scope of the 3 operative paragraphs is the same. The finding in the 1st paragraph that, quote, the temple of Preah Vihear is situated in territory under the sovereignty of Cambodia, end of quote, must be taken as referring, like the 2nd and 3rd paragraphs, to the promontory of Preah Vihear within the limits described in paragraph 98 of the present judgment. In these circumstances, the court does not consider it necessary further to address the question whether the 1962 judgment determined with binding force the boundary line between Cambodia and Thailand. In a dispute concerned only with sovereignty over the promontory of Preah Vihear, the court concluded that that promontory, extending in the north to the Annex 1 map line, but not beyond it, was under Cambodian sovereignty. That was the issue which was in dispute in 1962, and which the court considers to be at the heart of the present dispute over interpretation of the 1962 judgment. Nor is it necessary for the court to address the question whether the obligation imposed on Thailand by the second operative paragraph was a continuing obligation in the sense maintained by Cambodia. In the present proceedings, Thailand has accepted that it has a general and continuing legal obligation to respect the integrity of Cambodian territory, which applies to any disputed territory found by the court to be under Cambodian sovereignty. Once a dispute regarding territorial sovereignty has been resolved and uncertainty removed, each party must fulfill in good faith the obligation which all states have to respect the territorial integrity of all other states. Likewise, the parties have a duty to settle any dispute between them by peaceful means. These obligations, which derive from the principles of the Charter of the United Nations, are of particular importance in the present context. As is clear from the record of both the present proceedings and those of 1959-1962, the Temple of Preah Vihear is a site of religious and cultural significance for the peoples of the region and is now listed by UNESCO as a World Heritage Site. In this respect, the Court recalls that under Article 6 of the World Heritage Convention, to which both states are parties, Cambodia and Thailand must cooperate between themselves and with the international community in the protection of the site as a World Heritage. In addition, each state is under an obligation not to, and I quote, take any deliberate measures which might damage directly or indirectly such heritage. In the context of these obligations, the Court wishes to emphasize the importance of ensuring access to the temple from the Cambodian plain. The Court therefore concludes that the first operative paragraph of the 1962 judgment determined that Cambodia had sovereignty over the whole territory of the promontory of Preah Vihear, as defined in paragraph 98 of the present judgment, and that, in consequence, the second operative paragraph required Thailand to withdraw from that territory the Thai military or police forces or other guards or keepers that were stationed there. I shall now read out paragraph 108, which contains the operative clause of the judgment. For these reasons, the Court, 1. Unanimously finds that it has jurisdiction under Article 60 of the Statute to entertain the request for interpretation of the 1962 judgment presented by Cambodia, and that this request is admissible. 2. Unanimously declares, by way of interpretation, that the judgment of 15 June 1962 decided that Cambodia had sovereignty over the whole territory of the promontory of Preah Vihear, as defined in paragraph 98 of the present judgment, and that, in consequence, Thailand was under an obligation to withdraw from that territory the Thai military or police forces or other guards or keepers that were stationed there. I shall now call on the registrar to read the operative clause of the judgment in French. Vous avez la parole, Monsieur le greffier.
Merci. Par ces motifs, la Cour, 1. À l'unanimité, dit que la compétence, en vertu de l'article 60 du statut, pour connaître de la demande en interprétation de l'arrêt de 1962 présenté par le Cambodge et que cette demande est recevable. 2. À l'unanimité, déclare, à titre d'interprétation de l'arrêt du 15 juin 1962, que la Cour a, dans cet arrêt, décidé que le Cambodge avait souveraineté sur l'intégralité du territoire de l'éperon de Preah Vihear, tel que défini au paragraphe 98 du présent arrêt, et que, en conséquence, la Thaïlande était tenue de retirer de ce territoire les éléments de forces armées ou de police ou autres gardes ou gardiens thaïlandais qui y étaient installés.
Judges Ch.Ovada, M.Bennuna, and Д.Гайя append a joint declaration to the judgment of the court. Judge A.Кансаду, Trindade appends a separate opinion to the judgment of the court. Judges ad hoc Guillaume and Ch.Ovada append declarations to the judgment of the court. The text of the judgment is available from today in typescript. It will also be available shortly on the court's website. The printed text will be available in the near future. As the court has no other business before it, I declare this sitting closed.